So welcome and thanks for joining us today. As I said, my name is Jane Thorne and I'm from SUPC. SUPC is part of the SUMS group and we're hosting this webinar today on behalf of the UKUPC. And today we're joined by David Hansom and Sarah Duke, who are framework supplier partners from Clyde Co. And today we're going to be talking about transforming public procurement and preparing for changes to the PCR. So David's got a presentation. As I say, we've got Q&A, so please use the Q&A function, upgrade questions you want to hear from, and I'll hand over to David now, and he'll take it away on transforming public procurement. Thanks, David.
Thanks very much, Jane. Good morning, everybody, wherever you are around the country. I'm conscious it is Indian summer time. It is super warm and you're giving up an hour of your day to listen to this. I will, as ever, do my best to make the session as interesting and as relevant as I possibly can. The subject matter may not lend itself to witty anecdotes or trying to crack jokes, so will steer clear of that. But what I won't do is overrun on time. So we have 55 minutes for those of you timing me today left, and I want to make sure we've got some time for questions and answers at the end. We will, as Jane says, be producing a blog post to capture any questions that we can't answer today. And also Clyde is producing a series of commentaries on the Procurement Bill as it goes through its legislative journey. So if you would like to sign up for those, then please do so via our website. As Jane said, I'm David Hansom. I'm head of the procurement law team at Clyde Co. My team, amongst other things, specialises in helping universities and other education institutions to deal with all aspects of procurement, from soft market testing, early engagement, through to running procedures, and then seems to be a theme at the moment, but changing contracts, varying contracts, and looking at the material change provisions in the regulations, and also dealing with unhappy suppliers and dealing with, when they arise, procurement disputes. And I think there's something in the air at the moment. I think there's a bit of a trend in the sector. Without naming names, there's probably 4 or 5 suppliers who keep coming up again and again, and they might start with the letters M or T or S. But it's a busy market, and we're seeing at the moment real scrutiny on particularly the larger long-term contracts that a number of our university clients are entering into. So what are we going to cover today? Well, it won't have escaped your attention that the Procurement Bill 2022 has now been published and is making its way through the House of Lords and House of Commons on its legislative journey. This session is called Transforming Public Procurement. It's stolen from the name of the Green Paper, and that's certainly the government's ambition, as we'll see, in terms of the scale of reforms that's proposed. So I'm going to talk today about, let the slides work, there we are. I'm going to talk today about a number of different things, but first of all, in the spirit of interactivity, we have our first poll question, one of 2 questions today. Could you please vote on this question? Do you think the public procurement rules in the UK need to be reformed? And there's a yes or no answer, so no hiding. Please do vote now. Great, I'm not sure if that's closed now. So overwhelmingly not inconsistent with the responses we've been getting from a number of these sessions that we've been running, whether for individual institutions or for consortia. 91% of those attending think that the procurement rules do need reform, and only 9%, so 12 of you think not. Well, happily, your wish has been granted, and what we are looking at now is the really, I think, the biggest reform since 2006 in terms of public procurement regulation in the UK. So let's take half a step back and just set the scene. I think it's always helpful just to remind ourselves of where we were and how we got here. But obviously, we're going to spend most of today looking at what might be coming down the track. So I guess sort of pre-2000, public procurement was a feature of any public contract, in the sense that there were rules around compulsory competitive tendering historically in local authorities in the UK, and there were procurement regulations that sort of set out in broad terms how contracts should be awarded. As the role of the EU grew in terms of the single market, public procurement became a competence of the European Union, and with the aim of promoting the single market, so encouraging, in principle at least, the French not just to buy French, the Germans not to just buy German, and the British not to just buy British, the public procurement regime that we all know and love, or perhaps not, based on the votes of that poll, came to pass. And in 2006, we had, I guess, the first consolidated set of regulations, which came directly from EU law, and those were transposed into the UK rulebook. And then in 2015, we had Directive 2014/24 EC, which is the directive which gives us the current regulations that we have. Now, it wasn't on the side of a bus in 2016, but public procurement reform has become, it seems, a bit of a cause célèbre for the current UK administration, along with a number of other things that derive from EU regulation, such as state aid or subsidy control, which is also being reformed. And the government is really, in every interview you hear MPs or ministers talking about the sort of perceived benefits of Brexit. One of them is reform of the procurement rules. So the government now, through the publication of the Green Paper, Transforming Public Procurement, has said that it believes that procurement can be made faster, fairer, and more effective. And by doing that, the aim is to tailor our public procurement regime to the needs of the British economy, rather than what is seen by some ministers, at least, as being a compromise set of regulations that were agreed by 28 member states. And whilst the UK, it's fair to say, had a very strong hand in agreeing those regulations, the government is keen to capitalise, or seek to capitalise on this reform as part of that Brexit agenda. So on that basis, the current intention is that the UK will diverge away from EU procurement regulation, and judgments of the European Court of Justice will be instructive, can be noted by the UK English courts, by the UK court, but are no longer directly effective now that the UK's completed its transition period out of the EU. So what am I going to talk about for the rest of today's session? Well, I'm going to talk about how the rules will apply to your institution and apply to the work that you're doing, and we'll look at that in some detail. One of the biggest areas of feedback on the consultation, in terms of responses from the public sector or from bodies governed by public law, was what is perceived to be a huge step change in upfront transparency from the buyer in relation to what you're going to buy, when you're going to buy it, how you're going to buy it, and for the first time, how the contract's going to be run and how the supplier performed in delivering that contract. The transparency obligations are one of the aspects that leap out really from the draft bill. It's fair to say, and you will have all got this impression already, and those of you that have heard me speak on this topic before will know that I could talk very happily, I'm not sure whether you'd be as happy, but I could talk very happily about the procurement bill and all its many facets for at least half a day. So what I've tried to do here is to be judicious in terms of what we look at and the areas that we pick up. But of course, the Q&A can pick up any questions. Then we'll look at the new proposed rules on framework agreements, which I think is another key aspect for institutions, for those of you who are members of the UKUPC. I also then want to pick up on 3 cases just to try and bring some of the current landscape to life before we move into Q&A. I pride myself on not losing anybody during a webinar, and I don't intend to start that today, but let's hope that by the time we get to the end of the Q&A, there's something in here for everybody. So I touched on a lot of this already. I never talk to all of my slides, but this is really so that colleagues and when you come back and watch the exciting recording that we're making, you've got the full context in case you are stopped in the lift by a vice chancellor or by a member of the council or the senior management team. So I guess the journey here, we've seen the green paper that's been published. Many of you may have responded to that, and we've inputted into responses for clients. Alongside really the shake-up in procurement, the broader context here, we have the National Procurement Policy Statement, the NPPS. There have been NPPSs for a number of years. I think, and my sense and my spies in government tell me, that the NPPS is taking on a new significance, and we can expect that to be more detailed and for contracting authorities to be really expected to act in a way which is consistent with that through the statement itself and through a number of procurement policy notes, or PPNs. The Procurement Bill, which consolidates, and you will have heard this mentioned by different cabinet ministers on TV, consolidates a number of different sets of regulations, so public, utilities, concessions, defence and remedies, the current 5 sets of regulations into one act. Now, whether or not that's going to end in shorter legislation is a matter of some debate. The bill is already sizable, and for those of you that have read it, and as an aside, if any of you ever can't sleep or want to get away from in-laws or small children or pets over a long weekend, I can recommend a read of even the draft. By the time the bill is completed and all the schedules have been fully populated, and the secondary legislation, so the regulations that are promised under the Procurement Act are passed, and the statutory guidance that is promised to bolster or to give effect to a number of the provisions in the Act, the jury's out, certainly for me, as to whether or not we're going to end up in a shorter document by the time we've got to the end. As I'll say at the end of this session, when we're talking about what practical things are to think about now, the government has promised at least 6 months warning before the Procurement Act will be taking legal effect. So it may go through Parliament sooner, but what the government has said is that people need time for training, people need time to update documents, etc. And therefore there will be 6 months notice given to us. So, will the new rules apply to universities? A question I get asked a lot. Will the new rules apply to the same institutions as they do now? Well, in broad terms, I think the answer to that is yes. The definition of a contracting authority is slightly different in the new bill. It will apply to central government departments, arm's length bodies, or quangos, for want of a better word, of those departments, and the wider public sector, and that includes the health authorities, local government, etc., as well as utilities companies, where they are awarding regulated contracts, so contracts that relate to their regulated activity, as well as concession contracts. The definition of a contracting authority is slightly different in terms of how it's written, particularly in relation to the current exemption that applies for organisations that have a commercial or industrial character. But in essence, the legal test for a university will in the current drafting stay the same, which is a question of the extent to which the entity is exercising public functions and is under has financial dependency to or management control from the state. The reason why the majority of publicly funded tertiary education providers in the UK fall within the definition of a body governed by public law is where more than 50% of your income in one financial year comes from the state, including domestic student loans for tuition, etc. That's an analysis that you do year on year. We've helped a number of institutions from large to small, from research intensive to local post-92 institutions to look at that, and I've personally taken a number of institutions out of the regulations and all the changes that flow from that over the last few years. There's nothing in the Green Paper to carve out universities in the same way perhaps as the procurement of NHS clinical services is carved out of the bill, because that's going to be dealt with under the NHS long-term plan. So in essence, the current direction of travel is that if you're within scope of the regulations now, then all the signs are you'll continue to be in this new world. I do have a number of clients talking to us about whether we can bring forward that review to see whether or not whether the law continues to apply to the institution. I'm not sure that's linked directly to the law completely fundamentally changing in a year's time, but there may be a connection there. So the Green Paper doesn't contain anything specific for the education sector, or for any of you who are members of UKUPC, whether you are a university or not. So the legal test will still need to be applied on a financial year basis, looking forward based on projections in terms of income. And the other myth I'd like to dispel is that I hear a lot that we talk about opting out of the rules. It's not a choice, in the sense that the organisation either meets the legal test for a contracting authority or it doesn't, and that is evidenced in the case of this sector by the numbers, by the income split between institutions. And you'll all recognise, particularly those who are in finance roles or close to the finances of your organisation, you'll all know that can change year on year. I think I've just jumped forward. There we are. So I've talked about this already. Transparency is a key focus of the new regime. It's fair to say, as I've said, that it's one which has probably caused the most, the deepest, sharpest intake of breath across the public sector buying community. Transparency has been encouraged through the consultation going back to 2020. But a number of the comments and feedback the government received particularly from central government, but across the piece, was that really the transparency requirements as they were drafted in the Green Paper would have required the recruitment of several new staff, etc., simply to deal with the volume of administrative paperwork in terms of producing documents for bidders and for the market. So what we see now in the Procurement Bill, and it's worth reminding ourselves, of course, that at this stage we're just talking about draft legislation. It could and will in all likelihood change before we get to implementation. But it's right to say that the final proposals around transparency are diluted somewhat from the original Green Paper. And I think what's key there is that we'll see from this, as you see from the slide, the government is at pains to now say that transparency should be proportionate to the value of the contract and to the nature of the contract being carried out. But there are some baselines I'm going to talk to now. There was a proposal, and again, if I could hear any of you, I'm sure I might hear some sighs of relief here. There was a proposal initially that all contracts that were entered into by a contracting authority following a procurement would need to be published, and that has perhaps mercifully been dropped. However, there is an obligation in the current draft that any contracts worth over £2 million will need to be redacted for confidential, personal or sensitive information, which in itself is a skill, and we can talk about that when we get to questions, where the value is more than £2 million, as I say. Now that will capture a surprising amount of long-term or strategic contracts that your organisations will enter into. You don't need to spend much on an IT system. You don't need to be doing much building work of a new science lab or or student accommodation to get over that number. And actually, it's on those bigger, longer term contracts where redaction is going to be really, really important to manage. That's an example of the extra administrative burden. There was going to be an obligation to publish every submitted tender in relation to an above threshold regulated procurement. That again has been dropped. You can foresee stormy waters ahead if contracting authorities, I think, were disclosing each bidder's bid to each other, and the impact that would have on not least the protection of good ideas and innovative proposals that contractors may have had. I think one of the really big changes, and one that I think is going to have a profound impact, is the changes that are proposed to the debriefing and standstill regime. So currently under the 2015 regs, when you get to the end of your procurement, breathe a big sigh of relief. Your evaluators have done the scoring, you've got all the evaluation notes in, your evaluators, of course, have evaluated the bids against the published evaluation criteria and not against each bid. And you've come up with a winner, and you've come up with the reasons why the winner won, along with the marks for each of the other bidders. You then currently have to engage, and I don't know why this always seems to fall to us to do on a Friday afternoon. It seems to me that this is the most difficult bit of a procurement at the moment. You then have to do what is an entirely artificial exercise of comparison between the bids to come up with a standstill letter, which hasn't been done before in the procurement, because the evaluation's been against the criteria. It is difficult to convey to an inevitably disappointed bidder that they've been unsuccessful. It is difficult, particularly if the evaluation notes are, shall we say, not as complete as you may have liked, or don't perhaps give reasons that hold that much water. And you're faced with a fairly impossible task, I think, of translating the war information you've been given and turning it into a letter that can go to a bidder who is looking for any crack in the armour to try and persuade you often to change your mind. So that is going under it's proposed to go under the new procurement bill. The proposal now is there that, and I see a comment that someone's been there in terms of the joys of standstill letters, and I'm sure that you won't be the only one. The proposal now is essentially, in a nutshell, is to let the bidders do that comparison exercise themselves. The plan is that all bidders will be given redacted evaluation documents. So again, there's a job for us to do to redact that information, to take out anything which is commercially sensitive, personal, or sensitive, and provide the redacted evaluation documents on the winning bid, and then give the recipient, the individual unsuccessful bidder, their own documents privately. So everyone gets the redacted winner's version, and then each loser gets their own unredacted evaluation notes, leaving the bidders to do the evaluation exercise themselves. Now, the merit of that is that it saves you all the job of having to do that exercise. The downsides are perhaps obvious to see, which is that process is only going to be as good as the information you provide, and I think it is likely that certainly early on, that debrief pack will be scrutinised, not just by the bid team within the supplier, but potentially also by lawyers as well. And I think that one of the aims here is to simplify procurement. And I think whilst one can see what the government's trying to achieve, I think that the guidance and any regulations that sit around how this is going to work are going to be absolutely fundamental. Around COVID-19, PPE procurements, etc., there's been a lot of scrutiny and the judicial review litigation brought by the Good Law Project and others in relation to direct awards of contracts. And it's fair to say, if you look at Find a Tender, it's not just a UK phenomenon, because actually if you look at the official journal, it's the same across Europe, but there's been a huge amount of public contracts directly awarded in the last 12, 18 months, 2 years. Those have all largely been on the basis of Regulation 32, direct award by a negotiated procedure without prior publication of an AG notice or a Find a Tender notice, Sometimes it's a Regulation 72 material change to extend the scope of a contract to cover COVID period. But there's been probably an overuse of that of those exemptions, which are designed to be used in extreme circumstances only. I still see, and I'm sure you're still asked to look at direct awards even now. Sort of whilst COVID hasn't gone away, perhaps the immediate urgency has. I'm still asked to look at justifications now using COVID as the reason, and I think that it is a matter of time before one or more of those is scrutinised by a supplier. So there will now need to be a notice, a mandatory transparency notice for contracts which were awarded under extreme urgency or the comparable provisions of what is now Regulation 32. Other really important points to note, I think, here are that, and I touched on this already, there's a whole slew of new notices that are on the next slide or two, but there is a plan to have a publicly available register of supplier performance. So procurement law will no longer stop at the end of the 30-day limitation period for a procurement challenge, and everyone breathe a sigh of relief and move into the contract stage. There are going to be obligations on authorities to proactively manage the contract and to disclose to this central registry body the performance of the supplier against the key performance indicators in the contract to this central body. And where a bidder has performed poorly, where the contract's been terminated early because of KPI failures or other failures, and or has breached one of the grounds of mandatory or discretionary exclusion in the new Procurement Act, there is a plan for a debarment list for the first time. So this is sort of a theme which has been taken from other jurisdictions, not currently a feature of the EU law, but essentially a centralised debarment list which will contain the list of all bidders, the group companies, etc., that must not participate in a public procurement process across England, Wales or Northern Ireland for a fixed period. Now, you can guess where I'm going with this. I think the principle is a strong one. It is only as good as the data held in the central repository. I'm always quite sceptical of centralised sort of government repositories of data, because I think they can get out of date quickly, and the importance of making sure that that's updated is going to be key, because suppliers who are on that list are going to be locked out of the entire market for that period of time. And you can expect, I think, bidders to really scrutinise and appeal the use of the debarment list. There is a provision currently that allows us to exclude a bidder from a new procurement for prior poor performance on the old one, but it's hardly ever used because I think it's a combination of contracting authorities being terrified about getting it wrong and being challenged, and also the robustness of the evidence base for making that decision. So this should help to address the latter point, which is that there should be a more robust evidence trail. Whether or not authorities feel confident to use it is another matter. The light touch regime, so that's the regime that applies to social and other services, those currently listed in Schedule 3 of the Public Contracts Regulations, is going to survive, albeit in an amended form, and details of that will come through. So for those of you buying anything under the light touch regime, that will still exist. So there's a range of new notices coming through. I need to accelerate because I'm conscious of time. Range of new notices. I'm not going to talk to all these, but you can see here that essentially you're being asked in summary to set out in advance high value procurements for the year ahead, to formalise soft market testing. Obviously the advert goes out and the award notice, but the new ones are here. So contract detail notice, that's going to provide details of the contract award, the awarded contract. The implementation notice, that's about bringing the KPIs into the public domain. And there is going to be much more scrutiny on requirements to publish material changes, so Regulation 72 in current money changes. So an administrative burden here that I think once we've got used to it, will become second nature. But it's right to say that there are changes in that. So in terms of new procurement routes, so we've got the 5 currently. The proposal is that there'll be really just two: open and competitive, flexible, as it's been anecdotally called by procurement lawyers. That the clue's in the name. The idea is that you'll have flexibility to design a procurement process that works for you. So a mixture of comp dialogue mixed with restricted or mixed with negotiated to suit you, as long as it's fair, as long as you've published what you're going to do in advance, and it's non-discriminatory, i.e. you can't invite bidders that have been excluded at an earlier stage back into the final tender stage, etc. But there will be flexibility in principle to do all the things on this slide. I think the challenge there will be the confidence that we all need to have, that we're designing something which is fair and that works. I think there's a risk that we just all default into a restricted type procedure because we kind of know it. And I think that government is live to that and is talking about running training through the government, through the civil service college for contracting authorities around actually using some of those tools. Who's heard of the mystery shopper, now called the Public Procurement Review Service, PPRS? I prefer the name mystery shopper, but that's just me. Essentially, what the PPRS does is a free of charge, not time limited means for anybody, a student or an employee or a taxpayer or a supplier to complain about a procurement. The PPRS doesn't really have any powers of enforcement. It's obviously not great in terms of publicity, but it's a slap on the wrist. The new Procurement Review Unit, or PRU, is going to be made up of experts appointed by the Cabinet Office in public procurement. And whilst its remit will be similar, it will have a focus on looking at systemic or institutional repeat issues in procurement, and it will be able to investigate poor practice where suppliers report those and can make informal regulation. What's recommendations? What's the direction of travel here? I think the end game is to look at whether or not disagreements about procurements can be resolved other than through High Court proceedings. In some jurisdictions in the world, there is a procurement tribunal akin to an employment tribunal with lower entry points, lower fees, and in theory faster justice. Could it be that in 5 years' time the PRU is able to sort of dole out fines or penalties? Who knows? There is certainly that Henry VIII power in the draft legislation. In terms of remedies, I could talk for hours about the changes to the remedies rules, but essentially we are staying with High Court-based litigation. The automatic suspension is staying. The standstill period is being reduced. It's proposed to 8 working days from the current 10 calendar plus extension if it lands on a non-working day. There was a proposal in the Green Paper to cap the amount of damages that a bidder could claim to a multiple of the contract value. That has been binned, technical term, in the draft legislation. And also the proposal for an independent third-party contracting authority to do a review of what may have gone wrong before a claim can be heard has also fallen away. I think for reasons of cost and resource. So we are currently in the same waters as we are. We will be in the same waters as we are now. The focuses will be on post-procurement remedies, but automatic suspension will stay, albeit with a new legal test to decide whether that suspension should stay in place if one is brought. The government is committed to looking at a procurement tribunal or similar lower cost form, but that won't be the case for this new legislation. Supplier past performance, I've touched on this already. This register, and I said I'm a bit skeptical about, centralised, so in any country, centralised registries of information, but there will be a register of supplier performance. It will link into a new discretionary ground of exclusion for prior poor performance of the contract. It is going to, in all likelihood, require you to upload your KPIs for the particular contract to the register and the names of the suppliers, and to keep that information updated. And indeed, the guidance to the bill says that we'll be regularly encouraged to consult the register. Frameworks, now, no surprise, this is particularly of interest to my clients who are the consortia, but also for institutions that are either letting their own framework agreements or are looking to club together with others to put in place regional or pan-regional arrangements. But currently, a framework is an overarching set of terms and conditions that's run through a new procurement process, 4-year maximum duration generally. Terms and conditions, prices and specifications are generally set, and essentially there's no guarantee of any work, and you call down the contract that you need at the time you need it, either through a direct award or through a mini competition, i.e. reopening the competition with everybody on the framework. The plan in the new world is to have 2 types of framework agreement, open and closed. So closed is easiest, so let's deal with that first. Broadly speaking, as now, with again a 4-year maximum term. If you're on, you're on, you can't be added later, unlike a dynamic purchasing system. And there'll be rules on how to run mini competitions. What's new is the open framework. An open framework can be for up to 8 years, as long as you've got a minimum of 2 suppliers. And the plan there is that you set up your open framework, and to be open, it must be reopened at least once if the duration of the contract of the framework is more than 3 years or more. And there'll be limitations around how long it can be closed for, and that's a maximum of 5 years in the current draft. So essentially, what you've got is a framework for 8 years, and you're reopening that framework to allow certainly new bidders to join. Now, in the consultation, my team's view was well, what's the difference between an open framework and 2 closed ones back to back? If you're going to make the bidders that are already on the framework rebid. Again, I think we'll have to wait and see what comes out there in relation to that. But interestingly, again, it's all relative, but if you're a procurement lawyer, interestingly, the open model will allow criteria to be changed on mini competitions. Good news for the consortia, but charging suppliers for access to frameworks, although it happens widely now, will be expressly permitted. Conscious of time, but the biggie slide, and I guess what the practical takeaway for today, if you only take away a few things from what I've said, I think this slide's to cut out and keep. There are lots of changes coming. We haven't got the full picture because the Procurement Bill is not yet finalised, and none of the guidance or regulations are yet enforced. If you've started a procurement before the new act takes effect, then the starting position is that will be banked under the old rules, and that framework can run, that framework or that contract can run its course under the old regulations. There may be some transitional arrangements around remedies, but we wait to see. With any change comes sometimes uncertainty. With uncertainty comes boo-hiss work for solicitors. I think there is a real risk, or I think it's likely that there's the scope for more or not less litigation, or certainly more skirmishes around how procurement's been run, certainly in the early days. That's not a reason not to embrace the new regulation, the new law. And I think that in terms of updating template documents, training that we're running and others are running for our clients, just like today, and the Cabinet Office Civil Service College training will be really important to make sure that people feel empowered to use a number of these new flexibilities. I want to talk about some cases quickly, and I've just about got time. I've got 3 cases and 4 minutes, so let's see if I can do it. To really bring to life the landscape we're in now. None of these is necessarily higher education specific, but I think they all serve to illustrate a point, which is that the procurement challenge market continues to be incredibly active. 96% of cases that are issued never reach court. They settle, or the authority agrees to rewind partially or wholly the procurement process, or some other settlement is reached. But you are not immune to complaints and skirmishes from clients. There's a skill in spotting a complaint letter from a proper challenge letter, but these 3 cases all demonstrate, I think, interesting points. The first one, Biffa Waste Services and Leicestershire County Council, has the added bonus of being a case that we were involved in. This was a case for quite a lot of waste collection, and it was an argument, a summary judgment application by Biffa to essentially have the case decided in their favour without a trial, on the basis that the council was in breach of the procurement rules by anonymising the names of the other bidders in the process, and by anonymising certain information about the way that that process had been run. Essentially what happened was that the bidder guessed who the other bidder, who its competitor was in this procurement, made certain assumptions based on their market knowledge about how that bidder operated, and was wrong, and then lost the procurement, and said that it was a breach of transparency, equal treatment, and non-discrimination for the authority to act in the way it did. The court, happily, because we were on the winning side, didn't find in favour of the claimant on that summary judgment application, said there's no legal duty in relation to anonymised information. If you want to keep bidders' details anonymous for any reason, you can do, and that the speculation of one bidder wasn't something that could be dealt with by a summary judgment. So not sure how many of you do this, but for things like research projects involving experimentation, involving confidential patient records, or something which is sensitive, I think this is a helpful case. Interesting one, London Fire Commissioner. This is about the provision of respiratory protective equipment. Quite a small market, probably akin to why it's in here, probably akin to some of the quite small markets that a lot of your buying goes on in. Big contract, biggest in the UK, one of the biggest in continental Europe. Draeger lost and brought a claim which stopped the award of the contract. London Fire Brigade, now Fire Commissioner, applied to lift that suspension. Now, normally, I say normally, because it's difficult to draw any trends or themes really, because you can toss a coin on a lot of the judgments that come out on public procurement, often creating new law. But normally, the authority is successful in its application to lift on the basis that public interest is better served by the authority being able to award the contract for the student-facing service or for the particular requirement that you might have, and that damages would be an adequate remedy. And in this case, unusually, relatively unusually, the court said, no, this is a massive contract, it'll have an impact on the reputation of the supplier, and there are serious issues to be considered, so we're not going to lift the suspension, but we are going to order an expedited trial, which meant that the case would be heard sooner. So an automatic suspension application is not guaranteed to allow your contract to be awarded, depending on what you're buying and on the context. And the last one is education related. This is about date of knowledge. So generally speaking, unhappy losing bidders have 30 calendar days from the date they knew or ought to have known about a breach of the procurement regulations and to bring their claim if they so wish. Once you're outside 30 days, there is scope for the court to extend it up to 3 months where there are good reasons to do so, but the courts are very reluctant. One case, I think, 2 cases where that's been looked at. So broadly, you cut off at 30 days if you're an unhappy bidder, and normally you can breathe more easily on the buying side once you get out of that period. That date of knowledge can move depending on when bidders knew what. So generally speaking, a standstill letter will start the clock running for a challenge on the bidder being unsuccessful. In Bromcom Computers, the claim was brought outside of 30 days. This was a cloud-based IT system for 57 schools. Authority, the Academy Trust made an application to strike out the claim on the basis it's out of time. The court said that because and this is the wording from the judge, because the standstill letter was sketchy and inadequate, time hadn't started to run. So it is not enough to just put down a few words or a few reasons on a letter and hope that gets you there. And I think taken in the round against everything I've said today around transparency and the new focus in the new Procurement Act 2023 around the bidders doing the debrief evaluation assessment themselves, I think this is the hot topic for the next couple of years. As we move 1 minute over time, can we move into the last poll question, please, before we move to Q&A? So on the basis of all I've said, do you feel that your institution or your organisation will be ready for the new rules in 2023? Please vote now. Let's see if the outcome is the same, Grace, as where I've done this elsewhere. Yeah, I agree. I think it is too early to say. I think what the government is looking to do is to give us all the opportunity to think about our procurement, think about our procurement policy, think about our template documents, and attend training on different aspects as we go through. I think that there are bear traps in the draft legislation. There are more changes than perhaps meet the eye. I think procedural breaches will be will take place and will be scrutinised by suppliers. But I think we'll be in a far better position by the end of this year, start of next, to answer that question. So now 3 minutes over, but in my defence with the poll question, Jane, that's all I have. Thanks very much.
Thanks, David. So on behalf of UKUPC and SUPC, David, thanks ever so much for today. I think the Q&A and the interaction shows it was a really, really valid and worthwhile session. Thank you to Sarah also for being there when we needed us. Thanks to Grace and Marion again for hosting and doing the IT behind the session. So again, thanks very much, David. Slides will be available and the recording will be. So from us today, thanks very much.
Thanks so much. Bye-bye.